I returned from my 6-month work assignment in Houston to find a massive wooden structure sitting squarely on the back third of my property in Scottsdale, Arizona. My heart dropped into my stomach as I pulled into my driveway, staring at what appeared to be a brand new clubhouse complete with a covered patio, outdoor kitchen, and what looked like a pool area. The problem was painfully obvious to anyone with eyes. This building sat entirely on my land, not the common area where it belonged. My name is Preston Nichols, and I had purchased this 3-acre property specifically because of its size and privacy. The lot backed up to what was supposed to be HOA common land, but there was a very clear property line marked by the survey stakes I had personally placed before leaving for Houston. Those stakes were now gone, and in their place stood this monstrosity. I sat in my truck for a solid 10 minutes, just staring. My hands gripped the steering wheel so tightly my knuckles turned white. 6 months. I had been gone for exactly 6 months working on a major construction project, and in that time, the Saguaro Heights Homeowners Association had apparently decided my property was theirs to do with as they pleased. My phone buzzed with a text from my neighbor Mike. "Dude, you're back. Did you see the new clubhouse? HOA finished it last month. Looks great, right?" I got out of my truck and walked directly to where I knew my property line should be. The clubhouse wasn't just slightly over the line. It was a good 75 feet onto my land. The pool, the patio, the outdoor kitchen, all of it sat on property I paid taxes on. Property that was legally mine according to the deed sitting in my safe deposit box. I pulled out my phone and called the surveyor who had originally marked my property. "Thomas, it's Preston Nichols. I need you out at my Scottsdale property tomorrow morning, first thing. The HOA built something on my land." Thomas arrived at 7 the next morning with his equipment. By 9, he had confirmed what I already knew. The entire clubhouse structure, including the pool and all amenities, sat completely on my private property. Not a single inch of it touched the HOA common area. "Preston, this is bad," Thomas said, shaking his head. "They didn't just make a little mistake. This is a full acre of your land they've built on. Did they contact you at all during construction?" "Not once. I've been checking my mail, my email, everything. Radio silence." Thomas handed me the new survey documents. "You're going to need a lawyer. Like yesterday." I spent the rest of that day going through my records. The HOA had my contact information. I had made sure they had my Houston address and phone number before I left. I had paid my HOA dues on time every quarter through automatic payment. There was no reason they couldn't have reached me, which meant they had deliberately chosen not to. That evening, I drove to the HOA office, a small building near the community entrance. A woman in her late 40s with perfectly styled blonde hair and a pinched expression sat behind the desk. Her name tag read Deborah Chen, HOA President. "Can I help you?" she asked, barely looking up from her computer. "Yes, I'm Preston Nichols. I live at 4782 Desert Vista Drive. I just got back from a work assignment and discovered you've built a clubhouse on my property." That got her attention. Her eyes snapped up to meet mine, and I saw something flicker across her face. Not surprise. Recognition. She had known exactly who I was the moment I said my address. "I'm sorry, Mr. Nichols, but the clubhouse is on HOA common property. We had surveys done." I placed Thomas's survey documents on her desk. "No, you didn't. Or if you did, you deliberately ignored them. This structure is entirely on my private property. Not 1 inch of it is on common land." Deborah didn't even look at the documents. "I'll have to bring this up with the board at our next meeting." "When is that?" 3 weeks from now." 3 weeks. You built on my property without permission, and you want me to wait 3 weeks to discuss it. That's our policy, Mr. Nichols. We have scheduled meetings and we follow proper procedures. I leaned forward slightly. Here's what's going to happen. You're going to schedule an emergency board meeting within 48 hours, or my lawyer is going to file for an injunction and sue the HOA for trespassing, property damage, and whatever else he can think of. Your choice. Deborah's face flushed red. Are you threatening us? I'm informing you of my rights as a property owner. 48 hours. I left before I said something I would regret. On my way home, I called Marcus Rodriguez, a real estate attorney I had worked with years ago when I bought the property. We met the next morning at a coffee shop in Old Town Scottsdale. Marcus reviewed all my documents, the original survey, the new survey, my property deed, all my HOA correspondence, and my payment records. He sat back in his chair and let out a low whistle. This is cut and dry, Preston. They're completely in the wrong. The question is, what do you want to do about it? I want them to remove it, all of it, and I want them to restore my property to its original condition. That's going to cost them probably $300,000 minimum. Maybe more, depending on what's involved in the demolition and restoration. Not my problem. They should have checked before they built. Marcus nodded. Okay, I'm going to send them a formal demand letter today. We'll give them 10 days to respond with a plan for removal and restoration. If they refuse or ignore us, we file suit. They want me to wait 3 weeks for a board meeting. Of course they do. They're hoping you'll give up or settle for some compromised solution. We're not doing that. This is your land, and they committed what amounts to a significant trespass. The demand letter went out that afternoon via certified mail and email. I also started documenting everything with photographs and video. I walked every inch of my property, showing exactly where the clubhouse sat in relation to my boundaries. 2 days later, I got a call from a number I didn't recognize. It was a woman named Patricia Winters, the HOA's attorney. Mr. Nichols, I've been retained by the Saguaro Heights HOA to discuss the clubhouse situation. There's nothing to discuss. The structure is on my property. It needs to be removed. I understand you're upset, but perhaps we can reach an accommodation. The HOA is prepared to offer you a significant reduction in your dues, perhaps even waive them entirely for several years. No, Mr. Nichols, please be reasonable. The HOA has invested considerable resources into this amenity for the community. On my property, without my permission, the answer is no. The cost of removal would be substantial. It would likely require a special assessment for all homeowners in the community. Again, not my problem. Your client should have obtained proper surveys and permissions before beginning construction. There was a long pause. Mr. Nichols, I need to be frank with you. The HOA board believed the land was part of the common area. They relied on older community maps. Maps aren't legal property descriptions. My deed is clear. The surveys are clear. I'm not negotiating about this. Patricia sighed. I'll relay your position to my client. I have to warn you, though, they're unlikely to agree to full removal. Then we'll see each other in court. I hung up and immediately called Marcus to update him. He wasn't surprised. They're going to dig in, he said. HOAs have a tendency to believe they are above individual property rights. We need to be prepared for litigation. Over the next week, things escalated quickly. I started receiving letters from other homeowners in the community. Some were sympathetic, but many were angry that I was being difficult about a community asset. One letter from someone named Karen Hoffmeyer was particularly nasty. You're being selfish and unreasonable, she wrote. This clubhouse benefits everyone in Saguaro Heights. You should be thanking the HOA for improving our property values, not threatening legal action. Some of us actually care about our community. I tossed the letter in the recycling. I didn't owe Karen or anyone else an explanation for defending my property rights. The HOA's response to Marcus's demand letter came on day 9. They rejected our demand entirely. Their position, as stated by Patricia Winters, was that the clubhouse was built in good faith on what they believed to be common property, and that requiring its removal would constitute an undue hardship on the association and its members. Marcus filed suit the next day in Maricopa County Superior Court. We sued for trespass, injunctive relief requiring removal of the structure, monetary damages for the loss of use of our property, and attorney's fees. We also filed for a preliminary injunction to prevent the HOA from opening or using the clubhouse while the case was pending. The HOA fought the preliminary injunction. Their attorney argued that preventing use of the facility would harm innocent homeowners who had nothing to do with the decision to build. The judge wasn't sympathetic. The facility sits on the plaintiff's private property, Judge Patricia Morrison stated at the hearing. Regardless of the HOA's intentions or the impact on other homeowners, the plaintiff has a right to exclude others from his land. Preliminary injunction granted. That was 3 months into this nightmare. The clubhouse sat empty, locked, and unused while the legal process ground forward. The HOA board was furious, and I became persona non grata in my own neighborhood. Someone egged my house. Someone else left a nasty note on my truck calling me a community killer. Deborah Chen, the HOA president, started a petition to force me to accept a compromise. She went door to door, telling everyone that I was costing them money and preventing them from enjoying the new amenity. She claimed I was being greedy, that I wanted a huge payout when all the HOA had done was make a simple mistake. Mike, my neighbor, stopped by one evening. "Hey, Preston. I just wanted you to know I didn't sign Deborah's petition. I think what they did to you is wrong." "Thanks, Mike. I appreciate that. But I have to tell you, people are getting pretty worked up. There's talk of a special assessment to fight the lawsuit. Could be 10 or 15,000 per household. They should be mad at the HOA board, not me. This whole situation was completely avoidable." "I know, man, but you know how people are. They see that beautiful clubhouse sitting there unused, and they blame you instead of the idiots who built it in the wrong place." The discovery phase of the lawsuit revealed exactly how badly the HOA board had messed up. Marcus obtained all their meeting minutes, emails, and construction documents. What we found was damning. The board had received 3 different quotes for the clubhouse project. 2 contractors had specifically noted that surveys would be needed to confirm the exact location of the common area boundaries. The 3rd contractor, the one they ultimately hired, was the cheapest and hadn't mentioned surveys at all. The meeting minutes showed that board member Karen Hoffmeyer, the same woman who had sent me the nasty letter, had argued against paying for a survey. "We know where the common area is," she had said. "We've lived here for years. A survey is just a waste of money." Deborah Chen had agreed. "The old community maps show the common area clearly. We don't need to spend extra money on something we already know." Only one board member, a man named Robert Chen, no relation to Deborah, had objected. "I really think we should get a professional survey before we break ground. If we're wrong about the boundaries, it could be a huge problem." He had been outvoted 4-1. Even more damaging were emails between Deborah and the contractor. In one exchange, the contractor had mentioned seeing property stakes near the proposed construction site. Deborah had responded, "Those are old. You can remove them. My property stakes. The ones I had specifically placed to mark my boundaries." She had ordered them removed. Marcus was gleeful when he showed me these documents. Preston, they didn't just make a mistake. They were warned about potential boundary issues and chose to ignore those warnings. This is negligence, possibly even willful misconduct. What does that mean for the case? It means we're going to win. The only question is how much they're going to pay. We were about 6 months into the lawsuit when I received an interesting piece of mail. It was an invitation to the grand opening of the Saguaro Heights Community Clubhouse, scheduled for a Saturday afternoon 2 weeks away. There would be food, drinks, music, and a ribbon-cutting ceremony. I stared at the invitation in disbelief. Did they not realize there was a court order preventing them from using the facility? I called Marcus immediately. "They can't be serious," he said when I told him about the invitation. "There's a preliminary injunction in place. Apparently, they're planning to go ahead anyway. What should we do?" "Well, we could ask the court to hold them in contempt. But honestly, I have a better idea. How would you feel about showing up to their little grand opening?" "What do you mean?" "I mean, we show up, you and me, and we remind them in person and in front of all their guests that they're violating a court order by using property that belongs to you. It might be enough to make them finally see reason and settle." I thought about it for a moment. "I like it. Let's do it." The next 2 weeks crawled by. I kept waiting for the HOA to cancel the event, but there was no announcement. They were apparently going through with it despite the court order. The Saturday of the grand opening was beautiful, sunny and 78 degrees, perfect Arizona weather. I put on jeans and a button-down shirt, nothing too formal but presentable. Marcus arrived at my house at 1:30, wearing slacks and a polo shirt. "Ready to crash a party?" he asked with a grin. "Absolutely." We could hear the music before we even got close to the clubhouse. They had hired a DJ, and there had to be at least 100 people gathered around the pool and patio area. Tables were set up with food and drinks. Kids were running around with balloons. It looked like a proper party. We walked up the path toward the clubhouse, and I noticed heads starting to turn. People recognized me. The conversations began to die down as we got closer. Deborah Chen stood near the front entrance of the clubhouse, talking with Karen Hoffmeyer and 2 other board members. She saw us approaching and her face went pale. "Mr. Nichols," she said loudly, trying to sound authoritative. "This is a private HOA event. You're not welcome here." Marcus spoke before I could. "Actually, Miss Chen, this is Mr. Nichols's private property. You and all your guests are the ones who aren't welcome here. We have every right to use this facility. It was built for the benefit of the community." "You have a court order that says otherwise," Marcus continued. "By proceeding with this event, you're in violation of that order. I'd strongly suggest you shut this down immediately." Karen Hoffmeyer stepped forward. "How dare you come here and threaten us? We're just trying to enjoy a community amenity." "An amenity built on my client's property without his permission," Marcus said. "That's called trespassing." By now, the DJ had stopped the music and everyone was watching our confrontation. I could see smartphones out, people recording. "Good. Let them record." Deborah tried to recover. "We've been advised by our attorney that we have the right to be here while the legal matter is being resolved." "Your attorney is wrong," Marcus said flatly. "The preliminary injunction is clear. No use of the facility pending resolution of the lawsuit. I have a copy right here if you'd like to read it again." He pulled out a folder from his bag and handed her the injunction. She took it but didn't look at it. "This is ridiculous," Karen said. "All of this over some stupid property line. You're ruining everything because you want to squeeze money out of the HOA." I finally spoke. "I didn't build a $300,000 structure on someone else's land. That was your board's decision. All I want is my property back the way it was." That's impossible and you know it, Karen shot back. Do you have any idea what it would cost to remove all of this? We'd have to levy a special assessment on every homeowner. Then maybe the board should have done their due diligence before they started construction. A man I didn't recognize spoke up from the crowd. Why can't you just let us use it? It's not hurting you. Because it's my property. I pay taxes on this land. I own it. You don't get to decide how my property is used. But it benefits the whole community, a woman chimed in. Marcus held up his hand. Ladies and gentlemen, I understand this is frustrating, but the law is very clear on this matter. This structure was built on private property without the owner's consent. That's trespassing. The preliminary injunction prohibits use of the facility. By holding this event, the HOA board is in contempt of court. So what are you going to do? Deborah asked, her voice shaking slightly. Call the police, if necessary, yes. There was a murmur through the crowd. Some people started gathering up their things, clearly not wanting to be part of whatever was about to happen. Everyone stay where you are, Karen commanded. They're bluffing. They can't stop us from being here. Marcus pulled out his phone. Would you like to test that theory? Deborah grabbed Karen's arm. Don't, just don't. She turned to the crowd. I'm sorry, everyone. We're going to need to postpone the grand opening. Please gather your belongings and exit the area. Deborah, no, Karen protested. Karen, stop. We're making this worse. Deborah's voice was tight with anger and embarrassment. Slowly, reluctantly, people began to leave. Parents collected their kids. Someone turned off the DJ equipment. Within 20 minutes, the area was nearly empty except for Deborah, Karen, the other two board members, Marcus and me. Deborah looked at me with an expression I couldn't quite read. Anger, definitely, but also something else. Resignation, maybe. Are you going to report us for violating the injunction? She asked quietly. Marcus answered. That depends on what happens next. If the HOA is ready to discuss a reasonable settlement, we can overlook today's incident. What kind of settlement? Complete removal of the structure, restoration of the property, compensation for my client's legal fees and damages, and a formal apology. Karen laughed bitterly. That's hundreds of thousands of dollars. We can't afford that. You should have thought of that before you built on someone else's property, I said. The HOA has insurance, Marcus added. I'd suggest you file a claim. This is exactly the kind of situation liability insurance is designed for. Deborah nodded slowly. I'll bring it to the board. And I'll contact our insurance company. You have 1 week, Marcus said. After that, we're going to file a motion for contempt based on today's events, and we're going to push for summary judgment on the underlying case. We left them standing there, looking defeated. As we walked back to my house, I could hear Karen's voice rising in anger, though I couldn't make out the words. Well, that was interesting, Marcus said once we were out of earshot. You think they'll actually settle? I think today scared them. The contempt motion would be bad for them. And once their insurance company sees the evidence we have, they're going to put pressure on the board to settle. Insurance companies don't like paying for trials they're going to lose. He was right. 4 days later, Patricia Winters called Marcus to schedule a settlement conference. The HOA's insurance company had reviewed the case and decided it was indefensible. They wanted to settle. The settlement conference took place in a conference room at Marcus's law office. On one side of the table sat me and Marcus. On the other side sat Deborah, Karen, another board member named Susan Morris, Patricia Winters, and a representative from the insurance company named David Klein. David took the lead. Let's cut to the chase. Our position is that the HOA made an unfortunate error regarding the property boundaries. However, We believe Mr. Nichols's demand for complete removal of the structure is unreasonable given the costs involved. Marcus opened his mouth to respond, but I put my hand on his arm. With respect, Mr. Klein, there's nothing unreasonable about expecting people to remove structures they've illegally built on my land. The cost would be in excess of $400,000, David said. That seems disproportionate to any harm you've suffered. I didn't ask them to build a $400,000 structure on my property. They did that on their own. We're prepared to offer $300,000 for an easement granting the HOA permanent use of the land the clubhouse occupies, David said. That's more than fair market value for that portion of your property. Not interested. I don't want an easement, I want my property back. Karen couldn't stay quiet any longer. You're being completely unreasonable. $300,000 is a fortune. You could buy another property with that money. I already have a property, this one, which I purchased specifically because of its size and privacy. Privacy, Karen scoffed. You live in an HOA community. Privacy is limited. Actually, Marcus interjected, property rights in Arizona are quite robust, even within HOA communities. An HOA has no right to build on private property regardless of what community benefit might result. Patricia Winters spoke up. Perhaps we could discuss a compromise. What if the HOA removed portions of the structure so that nothing remains on Mr. Nichols's property except the pool? Would that be acceptable? No. The entire structure needs to go. David Klein leaned back in his chair, studying me. You're not going to budge on this, are you? Would you, if someone built on your land without permission? He smiled slightly. Probably not. Okay, let's talk realistically about removal. We'll need time to get demolition quotes to plan the logistics to arrange for restoration of the land. How much time? Marcus asked. 60 days to develop a complete plan, then whatever time is needed for the actual work. Maybe 6 months total. Marcus looked at me. I nodded. That's acceptable, provided we get it in writing with specific milestones and deadlines. And I want the property restored to its original condition, including regrading and replanting native vegetation. That's going to cost even more, David said. Again, not my problem. We spent the next 3 hours hammering out the details of the settlement agreement. The HOA would hire qualified contractors to remove every trace of the clubhouse, pool, patio, and all associated structures. They would restore the land to match the surrounding terrain and vegetation. They would pay my legal fees, which by that point totaled nearly $50,000. And they would pay me an additional $75,000 in damages for loss of use and enjoyment of my property. The total cost to the HOA's insurance company would be close to $600,000. Karen looked like she wanted to cry when the final number was presented. This is going to bankrupt the association, she said quietly. It won't, David assured her. The insurance covers it, but your premiums are definitely going up for the next several years. And there might be questions about board member liability for making decisions that led to such a significant claim, Patricia added, looking pointedly at Deborah and Karen. That got their attention. What do you mean? Deborah asked. I mean, if the insurance company decides to pursue subrogation against the board members who voted to proceed without a proper survey, despite being warned of the risks, they could potentially recover some of their costs from you personally. Karen's face went white. They can do that. Depends on the policy language and Arizona law on HOA board member liability. It's something you should discuss with your own attorney. The settlement was signed that day. I walked out of Marcus's office feeling vindicated but also exhausted. The whole process had taken nearly 9 months from the day I first discovered the clubhouse on my property. The removal process began 5 weeks later. A demolition crew showed up on a Monday morning with excavators and dump trucks. A small crowd of neighbors gathered to watch, many of them looking somber. Mike stopped by that first day. I know this was necessary, but it's still sad to see. It really was a beautiful facility. It would have been beautiful if they'd built it where they were supposed to, I replied. The demolition took 2 weeks. They had to carefully remove the pool, which involved draining it, breaking up the concrete, and hauling away the pieces. The building itself came down in a matter of days. The outdoor kitchen, the patio, all of it was systematically destroyed and removed. Once everything was gone, the restoration crew came in. They regraded the land to match the natural slope of my property. They brought in native plants, saguaro cacti, palo verde trees, ocotillo, brittlebush, and various other desert vegetation. Within a month, you could barely tell anything had been built there, though it would take a few years for the new plants to fully establish and blend with the existing landscape. The day after the restoration was completed, I walked the property with Thomas, the surveyor who had first confirmed the encroachment. We reviewed every inch of the work. "They did a good job," Thomas said. "Another few years and nobody will know anything was ever here." Good. I paid Thomas for his time and went back to my house. For the first time in nearly a year, I felt like I could finally relax. My property was mine again, but the story wasn't quite over. About 2 weeks after the restoration was finished, I received notice that there would be a special HOA meeting to vote on new board members. Apparently, the fallout from the clubhouse disaster had been significant. Multiple homeowners had filed complaints about the board's handling of the situation. The insurance company had indeed pursued subrogation against the board members, arguing that their negligence had directly caused the massive claim. Deborah Chen, Karen Hoffmeyer, and the 2 other board members who had voted to proceed without a survey had all resigned under pressure. Susan Morris, who had joined the board after the construction decision was made, was the only one remaining. I didn't attend the meeting, but Mike filled me in later. The association had elected an entirely new board, led by a retired engineer named Frank Morrison, who promised to implement strict new procedures for any future construction projects. There was also a vote to pursue legal action against the contractor who had built the clubhouse, since he should have insisted on proper surveys regardless of what the HOA board wanted. Frank gave a whole speech about property rights and due diligence, Mike told me. He actually mentioned you by name and said you were right to fight this. Got a pretty decent round of applause, actually. That's good to hear. I think people finally realized that the board screwed up, not you. Attitudes have shifted. He was right. Over the following weeks, several neighbors stopped by to apologize for the way they had treated me during the lawsuit. One woman, who had signed Deborah's petition against me, brought over a homemade pie and a card that said, "I'm sorry. You were right." I accepted the apologies graciously, though I didn't forget how quickly people had turned on me when it was convenient. The insurance company's subrogation lawsuit against the former board members moved forward. Marcus kept me updated since I was a potential witness. The insurance company was seeking to recover approximately $200,000 from the 4 board members who had voted to proceed without a survey. Deborah and Karen tried to fight it, but their own attorney told them they were likely to lose. The meeting minutes and emails were too damaging. They had been explicitly warned about the need for a survey and had rejected that advice to save money. That was textbook negligence in the performance of their board duties. They settled for $150,000, split among the 4 of them. Karen's husband apparently filed for divorce shortly after, the financial stress having destroyed their marriage. I heard through the neighborhood grapevine that they had to sell their house to pay their share of the settlement. Part of me felt bad about that. But the larger part of me remembered that all of this had been completely avoidable. They had made choices that led to this outcome. As for the contractor who built the clubhouse, the HOA's lawsuit against him went to trial. The jury found him 40% liable for the disaster, ruling that he should have refused to proceed without proper surveys and should have recognized that the property stakes he removed likely indicated a boundary issue. He was ordered to pay $240,000 to the HOA. Life slowly returned to normal. I continued working on construction projects around Phoenix and Scottsdale. My property remained quiet and private, exactly as I had intended when I bought it. About a year after the settlement, the new HOA board approached me with a proposal. They had identified a different location for a community clubhouse, this time definitely on HOA common property, with professional surveys confirming the boundaries. They asked if I would be willing to review their plans before they proceeded, as a sort of informal consultation. I agreed. The new location was actually better suited for a clubhouse anyway, closer to the community center and more accessible for most residents. Their plans were thorough and professional. They had learned their lesson. "This looks good," I told Frank Morrison, the new board president. "You've got all your permits, proper surveys, everything you need." "We're not making the same mistakes," Frank said firmly. "This board takes property rights seriously." The new clubhouse was built over the following year. I received an invitation to the grand opening, and this time I actually attended. It was a nice facility, not quite as large as the one they had built on my property, but well-designed and properly located. Frank gave a speech at the ribbon-cutting ceremony. "This clubhouse represents not just a community amenity, but a commitment to doing things the right way. We learned some hard lessons over the past 2 years. We learned that shortcuts and assumptions can lead to disaster. We learned that respecting property rights isn't optional, it's fundamental. And we learned that good intentions don't excuse bad decisions." He looked directly at me as he said that last part and nodded. I nodded back. The clubhouse opened without incident. People seemed happy with it, even though it was smaller than the original ill-fated structure. Maybe they appreciated it more because they understood what it had taken to get there. As for me, I continued to enjoy my 3 acres of private property in Scottsdale. The desert vegetation that had been planted during the restoration filled in beautifully. Sometimes I would sit on my back porch in the evening, looking out at that portion of my land where the clubhouse had briefly stood, and I would think about everything that had happened. It had been exhausting and stressful. It had cost me time, energy, and peace of mind. But it had also been necessary. Property rights mean something, and sometimes you have to fight to defend them. I never regretted standing my ground. Not once. Marcus and I remained friends. We would meet for lunch occasionally, and he never failed to bring up the clubhouse case. "Still my favorite case," he would say. "The look on their faces when we showed up at the grand opening, priceless. You enjoyed that way too much." Damn right I did. It's not often you get to see justice happen in real time like that. He had a point. Most legal cases are resolved in conference rooms and courtrooms, far from public view. Our little confrontation at the grand opening had been unusual, but effective. The special assessment that Mike had worried about never materialized. The insurance company covered the entire cost of the settlement, though as predicted, the HOA's insurance premiums increased substantially. That cost was spread across all homeowners in the form of a modest increase in HOA dues, about $30 per month. Some people grumbled about it, but most recognized it as the price of the former board's mistakes. The contractor, who had been found partially liable, appealed the verdict, but the appellate court affirmed the jury's decision. He ended up paying the full $240,000. I heard he went out of business about 6 months later. Another casualty of the Clubhouse debacle, Karen Hoffmeyer moved away from Saguaro Heights after her divorce was finalized. I ran into her once, about 2 years after everything ended, at a grocery store in Scottsdale. She saw me, turned pale, and quickly went down a different aisle. I didn't follow her. There was nothing left to say. Deborah Chen also moved, though I'm not sure where. She had been so proud of being HOA president, so certain of her authority and rightness. The whole experience had broken something in her. I saw her a few months before she moved, getting her mail at the community mailboxes. She looked tired and defeated. We didn't speak. The 2 other former board members who had voted with Deborah and Karen stayed in the community, but they kept very low profiles. I would see them occasionally at the grocery store or around the neighborhood. We would nod politely, but never engaged in conversation. As more time passed, new people moved into Saguaro Heights who didn't know anything about the Clubhouse situation. The story became something of a legend in the community, a cautionary tale that older residents would tell newer ones. "Make sure you attend HOA meetings," they would say. We had a board once that built a whole clubhouse on someone's private property. Cost the association hundreds of thousands of dollars. The details would sometimes get exaggerated in the retelling. I once overheard someone claim that the clubhouse had been 10,000 square feet, which wasn't even close to accurate. But the core message remained the same. Boards need to be careful and do their homework. 3 years after the settlement, I decided to sell my Scottsdale property. Not because of anything related to the HOA situation, but because I had been offered a long-term project in Denver that would last several years. I wanted to buy a place there rather than maintain 2 properties. The real estate agent I hired told me the property would sell quickly given its size and location. She was right. I had 3 offers within a week of listing. I accepted one from a family with 2 young kids who fell in love with the space and privacy. At the closing, the husband asked me about the HOA. "Are they pretty reasonable? Any issues I should know about?" I smiled. "They're much better now than they used to be. Very professional, very careful about following proper procedures. I don't think you'll have any problems." That's good to hear. Some HOAs can be a nightmare. They can be, but the current board here is solid. Just make sure you attend the meetings and stay informed about what's going on. After the closing, I drove through Saguaro Heights one last time. I stopped by the new clubhouse, which was busy with families swimming and kids playing. It was a good facility, serving its purpose exactly as it should. Then I drove past my old property. The new owners had already moved in. Their kids were playing in the backyard, running through the desert vegetation. It looked like a happy scene. I continued to the community exit and drove away, leaving Saguaro Heights and its complicated history behind me. The story could have ended there, but there was one final chapter that I didn't expect. About 6 months after I moved to Denver, I received a call from Frank Morrison, the HOA president who had taken over after the clubhouse disaster. "Preston, I hope I'm not bothering you. I got your number from your forwarding information." "No bother. What's up, Frank?" "I wanted to let you know that we've been contacted by a journalist who's writing an article about HOA overreach and property rights. She heard about our situation and wants to feature it as a case study. I wanted to make sure you were okay with that before I agreed to any interviews." "What publication?" "The Arizona Republic. It's going to be a Sunday feature article about HOA governance and the importance of proper oversight. I thought about it. The case was a matter of public record anyway, and maybe sharing the story would help other property owners who found themselves in similar situations. I'm okay with it. You can share the story. Would you be willing to talk to the journalist yourself? She'd really like to get your perspective. Sure, I can do that. The journalist, a woman named Rachel Kim, called me the next day. We talked for about an hour. She asked thoughtful questions about the timeline, the legal process, the emotional toll of fighting with my own HOA and neighbors. What would you say to other homeowners who find themselves in a similar situation? She asked near the end of our conversation. Don't back down if you know you're right. Property rights are fundamental. They matter. And don't let an HOA or your neighbors bully you into accepting something that's wrong just because it's easier or more popular. Some people might say you were being selfish by not allowing the community to use the clubhouse. Some people did say that, but it wasn't about being selfish. It was about the principle that you don't get to take someone's property just because you think you can use it better than they can. That's a dangerous road to go down. The article ran 6 weeks later. It was well written and fair, presenting both my perspective and the HOA's side of the story. It included interviews with Frank Morrison, with Marcus, and with several Saguaro Heights residents who shared their thoughts on what had happened. The article generated significant discussion online and in community forums around Arizona. Many people supported my position, sharing their own stories of HOA overreach. Others argued that I should have been more flexible for the good of the community. One letter to the editor particularly stuck with me. It was from a law professor at Arizona State University who taught property law. The Saguaro Heights case illustrates a fundamental principle of property ownership, he wrote. Rights come with responsibilities, and one of those responsibilities is respecting the rights of others. The HOA failed in that responsibility, and Mr. Nichols was absolutely correct to defend his property. To suggest otherwise is to undermine the entire foundation of property law. I printed that letter and kept it. The article also led to some unexpected consequences. 2 other homeowners in different Arizona HOA communities reached out to me through Rachel Kim. Both were facing situations where their HOAs had built or were planning to build structures that encroached on private property. I spent time on the phone with both of them, sharing my experience and Marcus's contact information. I don't know how their cases ultimately turned out, but I hope they found the same vindication I had. Looking back now, several years after it all began, I can see the entire experience with more clarity. Yes, it was stressful and difficult. Yes, it damaged relationships and caused conflict. But it also reinforced something I had always believed, that standing up for your rights, even when it's unpopular, even when it's hard, is essential. The HOA board that built the clubhouse on my property didn't set out to do something malicious. They genuinely believed they were improving the community. But they cut corners, they ignored warnings, and they assumed they knew better than the professionals who advised them. Those decisions had consequences. Karen Hoffmeyer, in particular, represented a type of person you encounter too often in HOA governance. Someone who is so convinced of their own rightness, so certain that their vision of the community is the only correct one, that they steamroll over anyone who objects. Her unwillingness to spend money on a proper survey, her dismissal of board member concerns, her anger at me for defending my property, all of it stemmed from an inflated sense of authority that had no basis in law or common sense. Deborah Chen was different. I think she genuinely tried to be a good HOA president, but she allowed Karen and others to pressure her into bad decisions. She went along with the decision to skip the survey. She ordered my property stakes removed, and she tried to proceed with the grand opening despite the court injunction. In trying to keep the peace and move projects forward, she failed in her basic duty to protect homeowner rights. The entire situation could have been avoided with a $2,000 survey. Instead, it cost hundreds of thousands of dollars, destroyed reputations and relationships, and created lasting damage to the community's trust in its leadership. But something good did come from it. The new board, led by Frank Morrison, implemented policies and procedures that made future disasters unlikely. They required professional surveys for any project affecting property boundaries. They required multiple quotes from contractors. They established a review process that included input from affected homeowners. They took their fiduciary duties seriously. Other HOAs in the area heard about what happened and made similar changes to their own governance. The case became a teaching example of what not to do. And perhaps most importantly, homeowners in Saguaro Heights and beyond learned that they had rights, and that those rights were worth defending. My time in Scottsdale is long past now. I built a life in Denver, bought a nice property in the foothills with even more privacy than I had in Arizona. I made sure there was no HOA this time, just me and the mountains. But I still think about that clubhouse sometimes. About walking up to it the day I returned from Houston and realizing what had happened. About the confrontation at the grand opening. About the long months of litigation and restoration. I think about Mike bringing over that pie to apologize. About Thomas, the surveyor, confirming what I already knew, that the entire structure sat on my land. About Marcus's enthusiasm for the fight. About the look on Deborah's face when we showed up at the grand opening with the court order. All of it was necessary. All of it mattered, because at the end of the day, if you don't defend your rights, someone will take them from you. They might do it with good intentions. They might do it believing they are helping the community. They might do it thinking you won't notice or won't care enough to fight, but your property is yours. Your rights are yours. And sometimes, the only way to keep them is to stand your ground and refuse to back down, no matter how hard the pressure becomes. That's the lesson of the Saguaro Heights Clubhouse. That's what I learned from that entire exhausting, frustrating, ultimately vindicating experience. And if I had to do it all over again, knowing everything I know now about the stress and conflict and difficulty it would cause, I wouldn't change a thing, because I was right. And being right matters, even when it's expensive, even when it's unpopular, even when it would be easier to just go along, especially then.